Hi, welcome back to my political channel. This is regarding Proposition 312, which is on the Arizona ballot coming up November, first Tuesday of November. And this is a proposition to ask you to add a law or modify a law in our state statutes. Let me pull this up for you and show you what it is. I need to share my screen so we can go over it. I think this is it. Let me see, 2023, yes. Yep, there it is. Okay, sorry for the delay. I want to make sure I got it for you. So you should be seeing the screen. This is the proposition which nobody reads. It's Proposition 312, which is House Concurrent Resolution 2023. This is refund failure to abate public nuisance. What is a public nuisance and what are we actually adding in here that our legislative districts refuse to tell you or have any oppositional presentation to these ballot measures? LD 28 is the one I'm in, and they had no discussion, no meeting on any of this, and they're going to walk around and hang this on people's doors saying, vote yes for this. Well, I want to give you an opportunity to have the other side. What is this doing? It says, notwithstanding any other law subject to the subsection, blah, 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 beginning in tax year 2025, the property owner may apply for a refund in the amount determined pursuant to this section if the following occurs. If your city or county or the town you live in refuses to, well, let's just read it, the city, town, or county in which the real property is located, that could be commercial or residential, adopts and follows a policy, pattern, or practice of declining to enforce existing laws, ordinances, or other legislation prohibiting illegal camping, obstructing public thoroughfares, loitering, panhandling, public urination or defecation, public consumption of alcoholic beverages, or possession or use of illegal substances. If they refuse to enforce these laws and use a property owner incur documented expenses, you have to prove through documentation that you have expenses to mitigate the effects of the policy. So if you have a situation on your property that is dangerous, unhealthy, and poses a safety hazard either physically or health wise, and the county, city, or town refuses to enforce these laws or has an ordinance that they or practice that they don't, you have to do something to mitigate it, and then you can get refunded only through the prior year taxes of your property. How does this work? Notwithstanding section 121134, subsection H, is in lieu of. So this, if you apply for this, it is in lieu of any claim for monetary damages or any rights under Title 12, Chapter 8 of Article 2.1, and I'll show you that. And your refund may not be in excess of the amount of the property owner paid in the prior tax year. The other problem with this is if the county rejects the refund, the property owner may file a cause of action in the Superior Court. So if they reject your refund request for the minimum amount of money that you have and the safety issue continues, you can file in Superior Court in which your real property is located. So in other words, in the jurisdiction that your property is located, to challenge the rejection of the refund. The question before the court is only going to be whether the property owner is entitled to the refund and whether the amount of the refund is reasonable. These are judicial questions. So there's nothing else that can be brought up. The fact that this is a safety hazard and the fact that it is a health hazard and the fact that the property is being contaminated by the actions of other individuals and the threat of this continuing is not even addressed. Only on this subject is that if the rejection was reasonable or if your request is reasonable. That's it. The city, town, or county shall bear the burden of demonstrating that its actions are lawful. That'll be difficult to do. But again, they're only addressing their actions are lawful in denying your request for a refund. That's it. No other actions are demonstrated under this section. Here we go. Section F. The property owner may not be required to submit any claim as a prerequisite to demanding or receiving just compensation in the form of a refund. Now, my question on this is, the county can just give you a refund even though you didn't ask, and now because you received and cashed that check, is that in lieu of the property rights that you are giving up? The property owner may apply for a refund under this section once per tax year only. If the policy, pattern, or practice of the public nuisance remains after the property owner applies for a refund, your property owner is entitled to another refund the next year. So in other words, it's permissive in allowing the cities, towns, or counties to persist in the violations of these actions. Look at Washington when you're talking about Seattle or Portland, Oregon, or San Francisco. These are LA, New York, Chicago. These are communities that are overrun by homeless populations. Drug use is allowed in those communities. Crimes are committed in those communities because of the situation that they're allowed. Now let me pull out of this section, stop sharing. I want to show you just what the public nuisance is. We have laws on the books that they're supposed to enforce. And this addition that they're asking you to vote yes for kind of grants them permission to not enforce them. We have public nuisance laws, 132908. This is a law that's on the books, public nuisance. I have to read it because I don't have, I can't read that small print. But it says, if by the conduct either unlawful in itself or unreasonable under the circumstances, such person recklessly creates or maintains a condition which endangers the safety or health of others. Wouldn't you agree that public urination, public defecation, public nudity, camping out on the sidewalk, drug use, increased crime, that's not creating a public nuisance? By knowingly conducting or maintaining premises, place, or resort where persons gather for purposes of engaging in unlawful conduct. The city, town, county themselves is violating this law as an entity by allowing it to go, and yet they're asking you to allow this by voting yes for this person. Now, when it says, let me show this to you. Well, there's another one. Public nuisance abatement. And they allow the public nuisance to continue on this 132917. It is a public nuisance and no less a nuisance because the extent of the annoyance or damage inflicted is unequal for anything to be injurious to health, indecent, offensive to the senses, or any obstruction to the free use of property that interferes with the comfortable enjoyment of life or property by an entire community or neighborhood or by a considerable number of persons. It's unlawful to obstruct the free passage or use in the customary manner. These are crimes that we have on the books now on our statutes that you're actually giving permission for them to continue this if you get compensated or if there's another avenue source for you to deal with it. This is wrong for the state. So I actually ask you my recommendation. I'm voting no for this. So look at this. What is the meaning? Person. It says any person. I like to use Black's Law Dictionary or other online services for legal definitions. What does person mean in legal sense? It says by the legal definition of person also includes legal persons, which are entities that the law recognizes having certain rights and responsibilities These government entities, cities, towns, and counties, have a responsibility under law to take care of these issues, even though they are not living, breathing individuals. These can include corporations, partnerships, trusts, and even government agencies. So they have an obligation to enforce these things, and this law is giving the in lieu of property rights that you may have under another title. The other title that they are talking about is concerning your right during confiscation of your property for public use. I don't see it. Let me see if I have this here. I'm not sure I do. But if they have eminent domain issues, the burden of proof is on the county or the city to show that your property is in need of being condemned. If they allow a situation to occur long enough, now they can condemn your property as being a health hazard or a safety hazard to the community that they created. So all they have to do is show, burden of proof is on them to show, hey, your property for the last 2-3 years has deteriorated to the point, commercial property, neighborhoods or whatever, to the point that it's a safety hazard, unhealthy, and for living conditions anymore. And now they condemn your property and they take it for eminent domain. This is a dangerous proposition, in my opinion. I've researched this and I think it is wrong for Arizona. I'm asking for my family, we're voting no. You make up your own mind, but this is just an awful bill. And why Mr. I think it was Ben Toma proposed this and put it out there. Why? I don't know. Ask him. Mr. Toma, why in the hell do you think this is a good decision to have the voters put into law? If the Republican Party thinks this is a good thing to do, I disagree. Our legislative districts were not allowing discussions on this. They just put it out there for people. They had maybe their committee meetings, but no pre-C had any input or opportunity to hear another side of this. And now they're going to go around and hang on everybody's door to vote yes. Not every district, but a large majority of them are saying vote yes on this, just because of the title. Well, let's get our property tax refunded if the county or city's not enforcing the law they're obligated to enforce, and they're letting an unhealthy situation materialize in a community that they encouraged or they created through mass migration and importation of people into our communities that they then let loose. I say no. This is not going to be a vote yes for me. I'm voting no on this, and I ask you to do the same. Randy Miller, thank you for listening to my video, and I'm going to see you at the next one.